Good evening and a warm welcome to the 22nd Kilbrandon Lecture. Hello, my name is Neil Quinn. I'm Head of Department of Social Work and Social Policy at Strathclyde. And I'm delighted to introduce Professor Ian Rivers, who's Associate Principal and Executive Dean of the Faculty of Humanities and Social Sciences, who's going to give some background to the Kilbrandon Lecture and introduce tonight's speaker.
Good evening and welcome to the 22nd Kilbrandon Lecture here in the lovely Barony Hall, which is the jewel in the crown of the estate of the University of Strathclyde. It's my delight and honour to welcome our lecturer this evening, Professor Emeritus Kenneth Norrie. And I very much look forward to hearing Kenneth's contribution to this long-standing lecture series. In fact, I was commenting yesterday, I'm seeing a lot of you recently, so it's very nice. I'm getting to hear a lot about the work he's done over the last few years. So there have been many distinguished lecturers for this series. They were inaugurated 22 years ago. I mean, Donald Dewar, the first First Minister of Scotland, was one of the first lecturers. Sir Harry Burns, Scotland's former Chief Medical Officer, and now a Professor of Public Health here at the University of Strathclyde, has also been a lecturer. The writer and broadcaster Frank Cottrell Boyce has also given the lecture, and last year we heard from Professor Phil Scraton from Queen's University Belfast. The committee which Lord Brandon established in 1960 led to the formation of Scotland's unique and globally respected approach to care and justice for young people, the Children's Hearing System. The hearing system is designed to ensure that children's needs as well as their deeds are considered wherever legal proceedings relating to care and justice concerning children arise. Since its inception, the system has contributed immensely to the care of children, to the greater respect of their rights and their futures. The Kilbrandon Lecture Series is a joint venture with the Scottish Government and the University of Strathclyde. The lecture, which was initiated by the University of Glasgow Centre for Child and Society, is now hosted by Strathclyde's Department of Social Work and Social Policy. I'm especially pleased that Professor Neil Quinn has agreed to chair the question and answer session following the lecture. We will also hear from Jane Kirkhope, a solicitor and legal manager for North Lanarkshire Council, who will respond to tonight's lecture. It is also a privilege to have with us Brian Taylor, Deputy Director of Children's Rights, Protection and Justice with the Scottish Government, who will deliver a vote of thanks at the end of the lecture. We're also joined by Nick Rougevie and Craig Milne from his team. Nicola Killane, Scotland's Children and Young People's Commissioner, is here, and representatives from local government and the voluntary sector, Police Scotland, and academic colleagues from across the country. I'm also delighted to have in tonight's audience individuals actively engaged in the lives of children and young people in Scotland, social workers, healthcare workers, teachers, members of the legal profession, and very importantly, our students and young people. You're all very welcome indeed. Lord Kilbrandon's legacy, our unique children's hearing system, touches all of the professions and services that interact with Scotland's young people. For this reason, this lecture series considers the vast range of issues that can impact on a child's upbringing and explores how together we can make Scotland the best place to grow up. The lecture is now an important part of the university's annual calendar. Our university was founded by Professor John Anderson during the Enlightenment to be a place of useful learning. The instructions in his will, which was not actually enough to cover the establishment of the university, and we had to go looking for some money, argued that it is important that this place is open to everyone, regardless of gender, status or income, and you'll recognize the values that we eschew as being keeping an ethos with the Kilbrandon lecture. We remain committed to useful learning as a university. We undertake high-quality research and knowledge exchange across key areas including children and young people and families, health and well-being, citizenship and communities, and of course, social and criminal justice. So now I turn to this evening's lecture. Professor Kenneth Norrie is Emeritus Professor of Law here at Strathclyde, where he has taught for 33 years until his retirement in 2023. Prior to that, he taught at Aberdeen and Dundee law schools, and he has held visiting professorships at Sydney, Cape Town, Wellington, Regensburg, and Vienna. He has published extensively on Scottish family law, including the textbooks Law Relating to Parent and Child and Children's Hearings in Scotland. He's also written widely on same-sex relationships, medical negligence, and legal history. He was commissioned by the Scottish Child Abuse Inquiry to produce a report on the legislative development of childcare law in Scotland from the late Victorian period until the present day. And from that work, he produced a book entitled A History of the Scottish Child Protection Law. He was himself a member of the Children's Panel for 10 years. He acted as an advisor to the Scottish Parliament and it considered bills that became Family Law Scotland Act 2006, the Children's and Adoptions Act 2007, and the Children's Hearing Scotland Act 2011. He is a Fellow of the Royal Society of Edinburgh and was awarded Law Teacher of the Year in 2007. And was a founding representative of the European Commission on Sexual Orientation Law. So, ladies and gentlemen, it is with great pleasure that I now call on Professor Kenneth Norrie to deliver this 22nd Kilbrandon Lecture.
Thank you very much for that kind and generous introduction. It is, of course, a very great honour to have been asked to deliver the 2024 Kilbrandon Lecture. As we've already heard, past lecturers have covered a whole range of different topics and areas. They've included politicians, healthcare professionals, journalists, authors, and the occasional lawyer. And having recently retired from Strathclyde Law School after 33 years as a child law specialist, I'm pleased to note that two of our most eminent lawyers who have been Kilbrandon lecturers, that's Lady Ailish Angelini and Lord Hope of Craighead, both have strong connections with Strathclyde. Lady Ailish is a visiting professor in our law school and a graduate of our law school. Lord Hope of Craighead, of course, was Chancellor of this university for many years. 2024 is the year in which both the university and the law school are celebrating their 60th anniversaries. And there's a pleasing symmetry, I think, to the fact that 2024 also marks the 60th anniversary of the publication of Lord Kilbrandon's famous report, which led to the establishment of the children's hearing system in Scotland. I said that I specialise in child law, and that's how the discipline is normally designated today. But in fact, my major textbook on the subject carries a rather more traditional title. Ian's already mentioned it, Law Relating to Parent and Child in Scotland. And that consciously refers back to Lord Fraser's important work, important 19th century work, Parent and Child, there's examples there. And this title, Parent and Child, I think better reflects the fact that for the vast majority of children, their parents are the most important people in their lives. The parent-child connection is the one that the legal system gives its most protection. But that immediately raises an important and surprisingly difficult question. Who in law is a parent? That's the question I want to explore in this lecture tonight. I was interested to note that in the recent Scottish Government consultation on the redesign of the children's hearing system, one of the questions, there's lots of them, but one of the questions asked is whether the hearings legislation should include a definition of parent. I answered that question with a resounding no, for many of the reasons that today's lecture, this evening's lecture, is going to touch upon. During my long years teaching undergraduate law students, I always emphasised to them this uncomfortable truth about lawyers. We are not loved. And amongst the many reasons for that, for lawyers being so disliked generally, is that we have a tendency to turn everything, including the most natural things in the world, into artificialities, from reality into abstractions. Lawyers do this because the law can only operate through a complex system of interrelated classifications, which are human impositions onto the natural world. And while these classifications may seek to reflect reality, they can only do so imperfectly, because the very process of classification acts to simplify the inherent complexities of life. But this distortion is essential in order to make these complexities administratively manageable. To give an obvious example, the law classifies human persons into children and adults, and there's sometimes an intermediate category of young person. To do this, the law often draws the line at particular anniversaries of an individual's birth, whether 12, 16, 18, or whatever. And later, we do exactly the same for age-related entitlements, pensions, bus passes, free television licenses, that sort of thing. Now, in reality, of course, every child grows up at their own pace. None of them, no child, wakes up on the morning of their 16th or 18th birthday with an intellectual and a physical capacity that they did not have when they went to bed the night before. So setting ages at which all young people acquire legal capacity is clearly artificial, though it's administratively convenient and indeed necessary for the efficient operation of the law. It would be a nightmare to require the seller of alcohol or tobacco or fireworks to have to do a personal assessment of the intellectual capacity of every apparently young person that tried to access them. It's much easier for the person just to show proof of age. Equally artificial, if perhaps less obviously so, is the definition of how the law identifies and defines the child's parent. Lady Hale famously said that there are at least 3 ways in which a person may be or become a natural parent: genetic parenthood, gestational parenthood, and social and psychological parenthood. But she was talking about social relationships. She made perfectly plain in the statement just before that and the statement afterwards that she was talking about the natural parent-child relationship, and she was not intending to give each of these 3 legal recognition with legal consequence. The law indeed has long recognised that there's a difference between legal parenthood and natural parenthood. The natural child of a natural father is what was called the illegitimate child, the person whose father was not married to their mother. The relationship was natural because it was recognised in nature, but it was not recognised in law, and it had minimal legal consequences. And you may actually be surprised to understand that shades of that position actually survived in Scotland until May 2022, or perhaps even May 2024, when the last natural child born before the Family Law Scotland Act 2006 attained the age of 16 or perhaps 18. A more obvious circumstance today in which we distinguish between legal and natural parenthood is with adoption, which allows the parent-child relationship to be created and indeed destroyed by court process rather than anything found in nature. Parenthood, in the eyes of the law, is as much a construct of the law as these obvious constructs of adult relationships such as marriage and civil partnership. And actually, What is natural about the natural relationship? We're used today to thinking that parenthood naturally comes from the genetic connection between parent and child. I'm going to become quite meta here, because that natural connection is itself artificial, in the sense that it's human choice. It's human choice to give social and legal consequence to the fact of genetic connection. The Romans, with little understanding of genetics, did not make that choice. And they had no problem in seeing fatherhood as a deliberate act of accepting one person as the child of another. Julius Caesar and Octavius, Trajan and Hadrian are only the best known examples of sons who became so simply by declaration of older men. It wasn't until much later in history, during the medieval period, that blood came to be seen as the crucial and only determinant of fatherhood. For this was the time when Norman notions of primogeniture solidified into our laws, and rights came to be devolved, jure sanguinis, by right of blood. Yeah. But an equally naturalistic way of looking at parenthood is to see it as a question of doing rather than being. The word parent can quite legitimately be used as a verb as well as a noun. It's no grammatical solecism to identify a parent as the person who actually parents the child, in the sense of being the adult who actually does the work of bringing the child up. I suspect this is almost certainly how children, especially young children, perceive who their parents are. So our legal system's choice, around 800 years ago, to locate parent in terms of blood rather than care is just as artificial as an adoption order. And it's worth noting that that choice had nothing to do with the interests of the child. It was made because of feudal society's need for certainty in property succession in a male-oriented world. And we can see this through the language that we use. Words are important. The word legitimate is used to describe, well, the word illegitimate is used to describe the natural child. But it's really important to understand that what was legitimate or illegitimate was never the child or the child's own existence. What was illegitimate was the child's claim to the father's estate, known, incidentally, in our law by the technical term legitim. Also think of the word adultery. Adultery, ground for divorce still in Scotland. Sex out with marriage. It's a ground for divorce because it risks, the act of adultery risks the adulteration of the male bloodline. That's where these words come from. So the concept of illegitimacy served a social function. Security of succession between males prevented disputes. In extreme cases, such as succession to the crown, it prevented fratricide and war. It stabilised society, in other words. The artificiality of parenthood is at its most apparent, I think, with statute law. Lawyers are natural Humpty Dumptys. We are always entirely comfortable with words in an Act of Parliament meaning whatever the legislator wants them to mean. So let's look at some statutory definitions of the word parent. And I'm going to start with the Social Work Scotland Act 1968, of course, the legislation that established the Scottish Children's Hearing System. 1968 Act tells us that the word parent means where the child is illegitimate, his mother to the exclusion of his father. So not all parents are parents. All mothers are parents, but not all fathers are parents. Parent also includes guardian, and guardian, we're told, is defined to include any person who has, for the time being, the custody or charge of or control over the child. The person who parents the child, in other words, is within the definition of the 1968 Act, of the definition of parent, but some fathers are not. Now, the key to understanding this fairly complicated provision, made even more complicated because the section numbers refer all over the place, the key to understanding this is to realise that its purpose, the purpose of this definition, was never to identify who a child's parents were, but rather its purpose was to delineate who had what today we would call the right of participation at a children's hearing. Parenting has always been seen within the children's hearing system as more important than genetics, and that actually explains why the natural father was excluded. It was assumed in the 1960s that when parents were not married to each other, only the mother would be involved in bringing up the child. Only the mother would be doing the parenting. That assumption continued in law long after it became palpably untrue, until that is the Children's Hearing Scotland Act 2011 came into force in 2013, a mere 11 years ago. And there's other bits of legislation on that slide which have very similar definitions of parent. Now, if you think that's a slightly peculiar definition of parent, wait till you see this one. This is section 47 of the Age of Criminal Responsibility Scotland Act 2019. Parent is a person who satisfies 3 conditions. To be parent, you have to be age 18 or over. By law, you're not a parent if you're under 18. Have to have parental responsibilities in relation to the child, and is related to the child. So you have to be related to the child before you're a parent. We're further told that being related includes being married to or in a civil partnership with a person who is related to the child. Now, read in isolation, this, I think, is next to meaningless. But it makes sense if you realise that what section 40 is doing is identifying a responsible person who can accompany the child to an investigative interview with the police. It's not about deciding who is the parent. It's using the concept of parent as a shorthand, a shortcut to the identification of who is appropriate to accompany the child to the police interview. In other words, parenthood, like it or not, in law is a mechanism to achieve particular purposes, whether imposing obligations to attend children's hearings, a police interview, universal issues like bearing the responsibility to bring up the child, or more venal issues such as identify who should inherit their property when someone dies. Who then in law is my parent? Let's start with mothers. Who is a mother? Mater certa semper est, said the Romans. Or motherhood is always certain. Mater certa semper est. This was never quite true. For even before the development of IVF and other infertility treatments, which confuse matters, we'll see in a minute or two, motherhood could be a matter of dispute. For example, if it was alleged that there was a mix-up at the hospital and the wrong child is sent home with the wrong parents, you sometimes read about that in the newspapers, or where immigration officers refuse to believe that a child that a woman is trying to bring into the country is actually her child, or, as in an 18th century Scottish decision from the House of Lords, where succession to land, wealth and titles turned on the question of whether Lady Jane Douglas had, at the age of 50, given birth to twin boys, as she claimed, abroad, or had instead sought to perpetrate a fraud on her aristocratic family. That's Douglas against Duke of Hamilton in 1769. What the Romans really meant was that there was no room for dispute as to how we define a mother. The mother is self-evidently the woman who was pregnant and gave birth. There may be difficulties of proving that, but these do not challenge that unquestioned truth. However, the development of infertility treatment, in particular egg donation, towards the end of the 20th century, challenged this age-old understanding of motherhood. Suddenly, the law was faced with the question, if the egg comes from one woman, is fertilized and then implanted in another woman, which of these two women is the mother? The common law had no obvious answer, and it could be argued either way. In fact, there was a third choice available. One indeed that may better reflect the reality of the egg donation situation. Both women make absolutely essential contributions to the creation of new life, so the law could have chosen to allow the child to have two mothers. Now, that third choice would have led to multiple social and legal complexities that was never seriously considered. And when the UK Parliament made its choice in 1990, it determined without any real discussion or opposition that the woman who becomes pregnant and gives birth is for all legal purposes the mother of the child. That's the Human Fertilisation and Embryology Acts, which I've cited, there. So that's the choice the British government made. Mothers are not defined genetically, they're defined gestationally. Now, it's interesting to note, I think, in passing, that the Supreme Court of Ireland in 2020, in the absence of any equivalent legislation in the Irish statute book, it came to the same conclusion on the basis of the Irish common law. And that's that case there in the middle. I'm not even going to attempt any pronunciation of that. But the point I'm seeking to emphasise here is that defining mother as one of the women who made one of the crucial contributions was a choice. It was artificial, though no less valid for that. It was a matter of human judgment and, not least, social and administrative convenience, rather than a matter of the law reflecting nature. Motherhood is of necessity a legal artifice, but it's a powerful one. And the strength of motherhood can be seen in the case of McConnell against Registrar General in 2020. This case involved a female-to-male transgender man by the name of Freddie McConnell. That's him there. And he became pregnant through infertility treatment, and he gave birth after his transition. He wanted to be regarded as the child's father, but the English courts insisted that he be registered as the child's mother, even although he had obtained, before becoming pregnant, a gender recognition certificate changing his gender from female to male. Now, what interests me about this case is why Mr. McConnell cared so much, given that the law never denied that he was, in one form or another, a parent. Well, he claimed that an official record, his child's birth certificate, revealing his transgendered history, was a breach of his right of privacy. He argued that the parental exception to the law's recognition of his change of gender in Section 12 of the Gender Recognition Act 2004 was a disproportionate interference with his private and family life. He asserted that the law was incoherent in declaring him to be, in effect, a male mother. And he said, from the child's perspective, the relationship was in reality a father-son relationship, while the law insisted that it was a mother-son relationship. The Court of Appeal rejected all of these arguments, and in doing so, emphasised that a child gains benefit from a second parent, irrespective of that second parent's gender identity, or sexuality. Notwithstanding that, a child always has a mother, even if the mother is, for all other purposes of law, a man. Mamma mia. Who is a father? Fatherhood is no less, and indeed more obviously, an artificial concept. It's been recognised as such for millennia. For it is a fact that has bedeviled the male psyche since the very dawn of time itself, that while women always know who their children are, men never do. Men have to rely on what women tell them. And it may come as a surprise, sometimes women are not truthful in this matter. So men struggle. For at least 800 years, the law has identified the father of the child with the provider of the male genetic material that led to the mother's pregnancy. Both socially and legally, we give that value, and that's the underlying premise of that otherwise fabulous film, Mamma Mia. But if you think about it, none of the three men who had had sex with the Meryl Streep character had ever acted, had ever been, in any real sense that mattered, a father to Meryl Streep's daughter. But it was an issue of importance to her, at least at the start of the film. Now, that film is set, of course, in the modern age, so the daughter could identify her genetic father. But for most of humankind's history, of course, it was a factual impossibility actually to prove the genetic link between a child and any particular man. The law since Roman times has got over this evidentiary gap by operating a presumption as to who the father of the child is. This is known as the pater est presumption, pater est quem nuptiae demonstrant, or the father is he to whom the marriage points. And there's a logic to this. Most children come about by sex, and married women are more likely to have had sex with their husbands than anyone else. So it's perfectly rational for the law to presume the connection between husband and child, the starting point of the presumption. Modern Scots law has an additional presumption. If the man's name appears on the child's birth certificate, he's presumed to be father because it's likely that he is, and both presumptions are now in that piece of legislation. Though today the evidentiary gap can easily be filled by a DNA test, these presumptions based on likelihood apply, even although we know that in a not insignificant number of cases, they're not accurate, they're wrong. But that's actually the whole point. Just as the rules of legitimacy enhanced social and familial stability in the Middle Ages, so too today, family stability is enhanced by the pretense that the register of birth is accurate in all cases until proven otherwise. So, paternity always was a fluid concept designed primarily to achieve social stability, settled lines of succession rather than anything else. But stability depends on stable definitions, and the definition of parent became far more fluid in law with the development of infertility treatment. This is because overcoming a couple's infertility often depends on using genetic material donated by a stranger whom no one intends to be the parent. Before the Human Fertilisation and Embryology Act of 1990, the donor of sperm was excluded from paternity only by keeping his identity secret. And the man who was attempting to become a father did so only by relying on no one challenging the presumptions that I've talked about. This was all very insecure. But the 1990 Act changed all that by removing the genetic link as the backstop determinant of paternity in cases of infertility treatment and replacing it with the notion of consent. Having removed genetics from the definition of father, the logical extension of these rules to female couples came about with the Human Fertilisation and Embryology Act 2008. But the 2008 Act does struggle with terminology when dealing with same-sex couples. The woman who gives birth is always designated the mother. If she has a male partner, he is designated the father. If she has a female partner, the 2008 Act can't quite bring itself to call her another mother. Instead, she's designated with the gender-neutral term, parent. Now, this makes little practical difference, but words carry emotional and political heft, as we've already seen in the case of Freddie McConnell. There's a premium to be had from having the status of mother rather than parent. Mothers are superior. Consider, for example, the case of Ray E. This involved a female couple who wished to have a child together. They attended a licensed clinic where one of them was artificially inseminated with donor sperm. She became pregnant. In the fullness of time, twins were born. The women registered the children's birth certificate. The women were registered on the birth certificates as mother and other parent. Unfortunately, when the twins were still toddlers, the parents separated, the women separated, and the fairly pedestrian contact dispute that followed soon became vicious. The mother opposed contact with the mother opposed contact between the twins and her ex-partner, with the devastating argument that the ex-partner was not a parent after all. She showed that the consent forms they both signed had been given to the clinic after the insemination process had started rather than before, as the Act requires. And the court held that since the conditions in the Act had not been fully satisfied, the woman registered as the children's other parent was not a parent at all of the children she had helped to plan into existence and bring up in their early years. Now, one of the major themes of this lecture tonight is that we shouldn't worry too much about the inherent artificiality of parenthood. But this is surely taking matters too far. The court demands that the Act be followed in every minute detail, including when a form is signed, seems to me to preference legal technicality over social reality. And worse, it suggests that motherhood, a natural trait, has a stronger claim to the law's protection than mere parenthood, which is a creation of the law. And this is not a unique case. P against Q was decided just a few months ago, earlier this year, and this also involved a female couple, but this time they were married to each other. And married female couples don't need to involve clinics or sign any forms. All they need is a blob of sperm. And frankly, the world's awash with the stuff. Through social media, they contacted a man who was willing to provide the genetic material they needed, and one of the women became pregnant, gave birth to a child. The birth certificate again showed both the women as parents. As in the previous case, the relationship broke down a few years later, and the mother sought a declaration that her ex-wife was not in law a parent at all. In this case, the problem was not the forms required by a licensed clinic, because no clinic was involved, there was no need to sign any forms. Rather, the mother asserted that as well as attempting to become parent through artificial insemination, she'd had sex with the man providing the sperm. Same man. Now, here's the problem. The 2008 Act only applies. Parenthood is only transferred from the man who provides the genetic material to the partner of the mother if the insertion of that genetic material into the mother is done artificially. But in this case, the closeness in time, we're just talking about a couple of days, between the mother attempting artificial insemination and the mother having sex with the man, that meant there was no scientific possibility of determining which insertion of the sperm into the woman, the sexual or the artificial, was the one that in fact led to the pregnancy. What was the court to do? Well, the Court of Appeal resolved the issue by utilising the ultra-legal concept of onus of proof. The onus lies, the court held, with the party seeking to dislodge the common law and seeking to establish that the 2008 Act applied. The ex-wife, in other words, had the burden of proving that the conception was artificial. Now, we know, and the court knew, that such proof was a scientific impossibility. So the decision on who had the onus of proving the impossible meant a decision as to who was to lose this case. And it seems to me that the court could just as easily have placed the onus on the mother, but it didn't. If you think about it, a man named on a birth certificate as father is presumed to be the father until that presumption is shown to be false. A woman named as the other parent on a birth certificate could equally have been presumed to be the other parent until that presumption was proved to be false. In other words, in this case, by showing that the 2008 Act did not apply. The court could have chosen to put the onus on the mother, but instead the court chose to put the onus on the parent rather than the mother. And this, again, is because the court conceptualised motherhood as something that trumps parenthood. We can also see motherhood being treated as stronger than any other form of parenthood in the slightly unexpected location of a Scottish children's hearings case. This is JS Appellant in 2021. This involved an unmarried, straight couple, now separated, who'd both been attending children's hearings for their child, after a couple of years, the mother declared that her ex-partner was not in fact the father. Since he'd not been registered as the father, and the couple were not married, this meant he had no presumption to rely upon, and the reporter indicated that therefore he could no longer be regarded within the children's hearing system as a relevant person. Now, the man offered to undergo DNA testing, but the mother, she was the one, remember, who put the issue in doubt. She refused to allow that doubt to be resolved and refused to make the child available for the testing. The sheriff resolved this fairly tricky situation by attaching to the compulsory supervision order a condition that the child be DNA tested. Though her motivations were good, my own view is that the sheriff made a clearly incompetent order, for all sorts of reasons that I seek to explain in that article in the Juridical Review that I cite there. But I mention the case here to show again the comparative strength of motherhood, in this case compared with fatherhood. Scra's argument that they could no longer treat the man as father once the mother denied he was father was wholly inconsistent with them previously having treated him as father on the mother's say-so. The English High Court earlier this year adopted a much more pragmatic approach to a similar issue in Ray D, the bottom one on this slide. This involved a couple in England who were having difficulty conceiving and they couldn't afford to access infertility treatment. So they came up with a plan. Why do people behave like this? The man mixed his sperm with the sperm of his own father. And that giant blob of sperm was then inserted artificially, it's implied, into the woman. The woman became pregnant and a child was born. Some years after that, for quite different reasons, the local authority became involved and instituted care proceedings in relation to the child. And the local authority sought to have the two men DNA tested to determine paternity. The application was dismissed on the ground that the local authority had no interest in the issue. In other words, determining who the child's father was no relevance to any issue that the local authority had to address in the child protection process. Now, for the avoidance of all doubt, I am not saying that finding out whose sperm had been used to create this child was unimportant. It may well be essential to the child's developing sense of self-identity to know whether his father was actually his natural brother and his grandfather actually his natural father. But that was an issue for the child and not for the child protection process. Mothers are important. Occasionally you don't have a mother at all. The infertility provisions in the Human Fertilisation Embryology Act 2008 trace parenthood through the mother, either to a father or other parent. But because they do so, they offer a route to parenthood only to opposite-sex couples and to same-sex female couples, only to couples where there's a woman. These provisions offer nothing to gay male couples, but the 2008 Act did give gay male couples access to the parental order after surrogacy. Now, the law of surrogacy is a complex and fascinating study, but what is particularly interesting for our purposes tonight is how the law and the courts conceptualise the parental order after surrogacy. The order is only available to a couple who are in fact parenting the child. It's designed to reflect that social reality. But the law also requires that there be a genetic link with at least one of the intended parents. At least one of them has to have provided the genetic material. And that genetic link is the justification for rejecting adoption as the mechanism to transfer parenthood away from the surrogate. People, we are told interminably, people should not have to adopt their own child. In other words, the intended parents are seen as the real parents, even before the order is sought. And the courts buy into this, and they've gone out of their way to ensure that the order when sought, is actually granted. I find it intriguing that while the courts have adopted an excessively strict interpretation of the infertility provisions in the 2008 Act, as we've already seen, they have at the same time adopted an extremely loose interpretation of the surrogacy provisions in exactly the same Act, even to the extent of ignoring clear rules set down by Parliament in relation, for example, to the time limits for applications. And I've listed here at the bottom of this slide the two Scottish cases, one by Lady Carmichael, one by Sheriff Sheehan at Edinburgh Sheriff Court, which do exactly this. They ignore the words of Parliament in order to make the order, and they explicitly follow dozens and dozens and dozens of cases down south that established these as precedents. What the courts have consistently done here is to treat the parental order after surrogacy as a means to regularise the situation, to reflect the parenting reality, rather than as a radical transference of parenthood from one set of parents to another, which is what in strict legal terms actually happens. Legal technicality in this instance gives way to social expectation. It's a rare example of parenting trumping parenthood. Now, there's another issue, another complication. There have been a number of cases before the UK courts in which female couples have informally received sperm from gay men in return for some involvement in the child's life. Often these arrangements work well, but very regularly cases come to court where relationships between the parties have broken down. The women on the one side, the man on the other. We call them the known donor cases. The breakdown of relationships is nearly always caused by the different conceptions of parenthood between the female couple and the men. And they're interpreting each other's words differently. When a female couple offer a gay male friend the chance to be a father, if he gives them some of his sperm, the man tends to interpret that as much more involving than the women mean and intend. What I find most interesting about these known donor cases is that in each of them, the men are attempting to create a new form or style of parenthood where they have status recognition, though less day-to-day care and involvement than expected of the traditional father, but they want some involvement and rather more than a non-resident father. Female couples, by and large, have preferred to replicate the nuclear model of family life, which excludes outsiders for all practical purposes, except where they determine otherwise. And the courts have resisted very vigorously moving beyond the nuclear model because they reject out of hand the idea that a child can have more than two legal parents, even when that's the reality on the ground. Many children are actually already recognised as having more than two parents. And this leads me to wonder if actually the key to a better conception of parenthood is to see it in essence as a bundle of legal consequences, which can normally be held by two people, but which in some circumstances will be spread more widely. And the bits of legislation I've put up there all are examples of legal consequences of being a parent which do not have a limitation to two. So the 1985 Act imposes an obligation of aliment. It captures step parents. Children's Scotland Act, parental responsibilities and parental rights. You can impose them on more than two people, and so it goes on. It seems to me that it's only in the field of succession law that there are strong policy reasons to restrict the number of our legal parents to two. That area is properly governed by principles appropriate to property and succession law rather than child law. Where does all this take us? Well, I've described the various complexities in the law's approach to parenthood in order to make two fundamental points. The first I mentioned right at the start: parenthood, like everything defined by law, is inherently artificial. But we shouldn't worry about this because it reflects the reality of many children's lives. By accommodating a variety of family forms, it avoids prejudicing children brought up in more unusual circumstances. Focusing on what's perceived as natural serves no purpose today, and certainly offers nothing of benefit to the child. Now, again, I need to emphasise, I'm not arguing that the fact of genetic connection should be ignored. We usually have emotional and sometimes medical significance. But I am questioning why in the modern world we continue to give it significant legal consequence. The second point that I want to make is that while every child is different and has different family circumstances, children are the same in one crucial respect. Above all things, they need stability in their lives, and they need the assurance that there are adults who love them and whose role is to put their interests first. Children are astoundingly resilient creatures and can cope with any family structure so long as it provides them with that stability and that assurance. And the role of the law, it seems to me, is to seek to ensure that stability by regarding parenthood in its many different guises as an anchor for every child, which is immovable, even if their life circumstances change due to the evolving relationships of the adults around them. I find deeply disturbing the cases I've talked about this evening, where people who were originally regarded as the child's parents have had that status taken away from them on legal technicalities, in cases that are not primarily about, and none of these cases are primarily about, who the child's parents are. Professor Gillian Black has made a powerful argument in that juridical review piece that's out there that we in Scotland should adopt the approach common in continental Europe of severely restricting the mechanism and title for challenging established parent-child relationships. I find that persuasive, if for no other reason than that cases where parenthood is challenged are all about, every one of them is about serving adult interests, even if wrapped up in child welfare language. That's a whole problem in child law. Other than with adoption, where the child's interests are central to the whole process from start to finish, I would make it virtually impossible to remove a person's parenthood once they've been officially recognised by whatever means as having some or all of the attributes of the parent. An individual attribute of parenthood, such as having parental responsibilities and parental rights, can of course be altered, but that should happen only when the child's welfare is the real issue at stake, and not simply a mechanism to further adult interests. Taking both these points together leads me finally to answer the question I set myself in this lecture. Who then in law is my parent? And the answer, I'm afraid, is that typical, frustrating lawyer's response. It depends on the circumstances and can have a different answer in different situations. If you find that unsatisfactory, then even more so, I fear, is the typical, frustrating academic's response that the question is ultimately meaningless. Because what's important to the law are the various consequences that flow from the recognition of a particular connection between a child and an adult, irrespective of what you call that connection. Of course, I've already accepted that the words we use to describe these connections do have social significance. But perhaps we need to leave it to the children themselves to develop their own language, to capture their own perceptions of who the adults around them actually are and what they want to call them. That, rather than a focus on genetic inheritance or legal technicality or adult interests, seems to me to be a better recipe for ensuring the well-being of all children, whoever their parents are. Thank you very much.
Thank you to Professor Norrie for that very informative lecture. I'd now like to introduce Jane Kirkhope, who's a solicitor and legal manager with North Lanarkshire Council, to respond to the lecture.
Thank you very much. I'm not sure, as a solicitor, if I'm the most popular person in the room at the moment, I have to say, but thank you very much. That was absolutely fascinating. I am obviously delighted to be responding to Professor Norrie's illuminating and entertaining lecture on the topic of who then in law is my parent. I had planned on listening attentively and picking out some pertinent, interesting points, but as you will appreciate, everything in that was interesting and pertinent, so I'm struggling. At risk of just basically repeating everything that you've said, I'm going to go through and try to extract some of the more standout moments for me, but it was all absolutely amazing. In anticipation of the lecture today, and having never attended a Kilbrandon lecture myself before, and having a thinking about the topic, I thought, well, why does it matter, actually, why parent is defined either in law or as a social construct? I'm a parent and I'm a mother. I think I'm a mother after that. I'm not entirely sure. I'll have to go and define that later on. But yes, why is it important? So I did a wee memory refresh on the kind of the history of the Kilbrandon lectures, and actually going back to the report itself, because sometimes it's quite nice to go back to basics just to see where we're all coming from. And certainly within the context of the children's hearings system, the report places the child at the centre of decision making in regards to the family, and the parent in particular as being essential to that decision making process. So there we've got the parent already front and centre beside the child. And the report envisages decision makers working closely with parents based on an underlying assumption that all parents are fundamentally good and that they're people who have the best interest of the child at heart. Possibly in modern times that has been slightly overridden somewhat. It's certainly not the case. I'm not the perfect parent myself, I have to say, I have to confess, although I'm the perfect mother. Scots law is littered with references to parent encompassing different scenarios, as Professor Norrie outlined with his references to the various statutory definitions of parent. So these are all reasons why it's important that we understand what parent actually means in order to navigate our way through the legal system and just life itself. So having said that, what is the answer then? Well, I think unfortunately that's easier said than done. As a lawyer, I do like black and white answers, or at least I think I'm often accused of liking black and white answers. But I think as a lawyer who's been in practice in local government for a long time, I realise that very often that's not the case. So I was looking forward to getting some answers here today on that. I was interested to see Professor Norrie's references to Lady Hale's quote about a natural parent as opposed to a legal parent, and then going through the slightly word salady, if you like, definitions of parent within statute, which is very much the world that people like myself inhabit. And sometimes it's very easy to get caught up in that world and jumping from one definition to another and trying to make a kind of one-size-fits-all and realising that's actually just not possible. And what I really took today was almost a sigh of relief that the law is there to help us define parent for a specific purpose. It's not there to try and say this is who your parent is, this is who your parent is for this specific type of proceedings, representation, participation, and that actually felt like stupidly a bit of a light bulb moment for me. Even though that's what we were doing, I was suddenly able to put that into some context. As well as the word parent, of course, it's not as simple as that. We then have to get into mother and father as well, which is yet going down another rabbit hole of interpretation. Looking at, for example, presumptions of paternity, again, I'm seeing more and more these are artificial constructs. Things seem to be becoming less and less certain in my black letter of the law head about what parent or mother actually means. We then heard about something that I thought was particularly interesting, the DNA testing, the circumstances within which the courts and the children's hearing are willing to order testing to be carried out. What I found illuminating about that was the requirement to really drill down into why the local authority in one instance or the father was looking for the DNA testing to be carried out. It's purely wanting to find out who the biological parent is isn't enough of a reason. as Professor Norrie said, that can be absolutely vital. It probably is vital for the sake of the child. For example, in the was it Reed D case, which was particularly fascinating, about the mixed up sperm. Of course, that's vital, but in the context of that particular situation, it wasn't necessary for the DNA testing to be carried out, which is something to bear in mind. Going on again to the topic of surrogacy and male couples, again, absolutely fascinating. And I thought that particular section was very interesting in seeing almost like the evolution of the parental order, going from something that was attached onto married couples back in 1990 to being extended to unmarried and same-sex couples in 2000, and finally the concept being developed further in case law to include a situation where a male couple has actually broken up. We have an example here of the law operating to extend a definition to reflect what's happening in society as a whole. I actually had a look at the AB and PM cases in anticipation of today, and a phrase that I'd noted was a liberal and constructive approach to the construction of the legislation that was in point at the time. And just the phrase a liberal and constructive approach I thought was particularly interesting and very in keeping with the lecture we've had today about trying to, sometimes we have to try to make the law fit to the situation that we have and not try to be too bogged down in what it says. And that particular concept goes through into the discussions about new family structures, multiple parent families. How do we recognise the concept of a parent legally within these new family structures? It's not easy, as we've seen, but we have to try and make the law work for us in the particular scenarios that we might be before a court for it. You know, many children have more than one parent, therefore can the legal consequences be felt more widely for these particular children. As Professor Norrie said, many acts do recognise the fact that children are parented. Now, in terms of conclusions, I was hoping to get to the end and be able to have written down a parent in the eyes of the law is such and such a thing, and then I could also go back to my day job and it would be really easy, and I would have a one answer for every single query, but it's not like that, and I actually wouldn't like it to be like that because life would be boring, wouldn't it? My biggest take from this is that parenthood is the person who parents, and I think that's my instinct as a parent. And it's probably my instinct as a lawyer as well. We don't want to get bogged down in legal technicalities. The person who parents shouldn't be removed because of a legal technicality. And I thought it was very interesting as well, your very final comments there, Professor, about the views of the child. And you know, I was particularly thinking that sits so nicely with the incorporation of the UNCRC you know, into our domestic legislation and placing the child at the centre of the decision-making process. And going forward, and perhaps this is something that might come up when we open up for further questions, is whether you think that there could be any scope for the concept of parent to be opened up even more widely and become even more fluid off the back of the UNCRC, if that could be a catalyst, if you like, for this to develop even further. That's the end of my thoughts. I'm extremely grateful to have had the opportunity to share this podium with Professor Norrie, and I will take a seat, and then I believe there's going to be more questions. Thank you very much.
Thank you, Jane, for that very thoughtful response to Professor Norrie's lecture. So we have 20 minutes for, I guess, question and answers session. So it'd be good to hear from all of you. So Nadia is going around with a roving mic. So if you introduce yourself with your name and association or organisation, if you have one. So. And we'd like to start.
Thank you there. Jonathan Brown, lecturer here at Strathclyde, and thank you to Professor Norrie for that absolutely excellent lecture. I'm going to have to ask Professor Norrie to mind his P&Q at the moment, by which I mean my question is about those groups of cases involving parenthood, motherhood and so on. You mentioned Roman law at the outset and the fact that this presumption pater est quem nuptiae demonstrandit, the father is he who is married to the mother, essentially. And with these cases involving two women who are married to one another, yet this idea of motherhood having superiority over parenthood, I just wonder, being that the Romans did not have lawfully recognised same-sex marriage, they had same-sex weddings at points, but the marriage was not legally recognised. On the basis of the fact that in our society now same-sex marriage is a legally recognised thing, is it not perhaps justifiable to alter the presumption from pater est to parens est, meaning that this is one mechanism by which, if a woman is married to another woman, motherhood and parenthood can be taken to subsist within the context of that family relationship? And in relation to that as well, I'm wondering, given that these cases were English, is there anything within Scots law and Scots jurisprudence that would suggest that the Scots courts really ought to not only socially but legally tread a different path from what has been decided down there?
Thank you very much, Jonathan, for that rich question. Jonathan is our Roman lawyer, will know probably more Roman law than I do. In a sense, one of the answers is easy, whether it should no longer be pater est quem, it should now be parens est quem. That, with respect, slightly misunderstands what the presumption does. It fills the evidentiary gap. It fills the gap between where the sperm came from. So we couldn't use that for female couples because we're trying to... Female couples want sperm without a man attached. So you want... So the law had to develop a mechanism, which it did quite successfully in the 2008 Act, to identify the other parent, and that's the connection with the mother and all the consent business that goes on. So it couldn't quite do that. I mean, the other thing you're right about, of course there was not really same-sex marriage in Roman law. I'm not entirely convinced there was any marriage in Roman law, in the sense that we understand it, because there was no law of marriage. There was no Roman rules as to how you get married, who was entitled to perform the ceremony, anything like that. There were the occasional rules about disabling legionnaires from marrying while they were on duty, that sort of thing. But that's the nature. Marriage was a very, very informal process in Rome, which is why divorce was so easy to get out of, because so what I'm saying is the conception of marriage in Roman times was just so different from our conception today, which has been traced to the sacramentalization of marriage in about the 11th century. So it's kind of different. So I'm not sure it's hugely helpful to wonder how the Romans would have dealt with these things.
Thank you. Any other questions?
Ruth Stark. I'm a social worker, so I'm going to speak from a kind of social concept around, and I'm fascinated by, towards the end, when you actually mentioned multiple parents, and that for children now is, for many of them, a reality. But I wanted to pose a question to you around, are we perhaps returning to more indigenous ways of organising and family functioning, thinking in terms of the African proverb and the reality that it takes a whole village to bring up a child. And we now have children being brought up by many significant adults in their families who may or may not be your prescribed parent, but in the legal definition. But the reality for them is that these are significant people for them. And does it take us back to that Roman concept about how do children grow up in our society? And so perhaps we should be thinking more in terms of what we know from social anthropology, in terms of family functioning and what purpose it takes. But I'd also like to add in to that train of thought, because you didn't talk about the corporate parent. And for some of us in the audience, that's a very real question about what is the role and the function of a corporate parent. And is there a better way, now we're so many years on from the Kilbrandon concept, of rethinking that whole business about permanency orders and adoption, particularly given how children, as they are in their teenage years and growing into their 20s and 30s and 40s, are searching out their biological parents. So I'm trying to widen this out a little bit just to think, where does your challenge leave us thinking in terms of where we take the next stages in terms of understanding about what is in children's best interest?
The first point about whether we're moving back to a much older way of seeing parenthood, I think is actually very insightful. And I blame marriage for an awful lot of things. Marriage became the major social legal construct which governed society about 1,000 years ago, and it has governed how we think about the family relationship for far longer than actually it has proved useful. Now that few things are traced directly to marriage, it does give us scope and flexibility to acquire a new way of looking at children. I think I've not fully worked out this idea of parenthood being a sort of multi-strand string, but I think it's quite, we no longer have the constraints that a strict marriage regime imposes upon us. In terms of the future and corporate parenting, I thought about mentioning corporate parenting. It's a bit of an excuse, I didn't find time. But it is another example of a legal construct being used to achieve a particular end. Personally, I'm not that fond of the phrase corporate parenting. I've never terribly liked it. I remember 2 principals ago in this university, the principal's wife tried to argue very strongly that we should involve parents in their children's education. And she said, because after all, we're all here at the university in loco parentis. And I slightly burnt my boats with the woman because I opposed it and said, well, to be in loco parentis, you need somebody to be in loco liberos. You need a child. And at universities, we're not dealing with children. We're not dealing with children. The UN Convention was mentioned, and could I maybe just pick up the point you made about the UN Convention and whether this will influence our definitions. I think it's very interesting that there is a definition of child very clear in Article 1. Again, I don't like it because it infantilises the 16 and 17-year-old. I've said this often. But there's a clear definition of child in the Convention, and there is absolutely no definition of parent. But I quite like that too, and I think you've got to remember that the UN Convention is a worldwide document, and it takes account of all the countries in Africa, South America, the global South, and it very deliberately avoided going down that rabbit hole of seeking for a definition of parenthood, because different societies have completely different perceptions of that word. So I quite like the fact that there is no definition there. I feeling there was something else in your question, but I think...
I wondered, Jane, do you want to speak about corporate parenting? Do you have any comment?
Oh, sorry.
Thank you. Just think that didn't look like a microphone. Yeah, I deliberately didn't mention it either for similar reasons. I don't like the term. I also, in my day-to-day existence as a local authority lawyer, it doesn't really mean anything. You know, I feel like it's a figurehead, excuse me, who doesn't have personally, as you were saying, any particular authority over that child, whereas the council kind of has it, but it just doesn't feel right to have that kind of corporate pain. So I tend to avoid the use of the word. Funnily enough, I was speaking to my sister, telling her I was coming here to do this tonight, and she's not a solicitor, she's nothing to do with childcare or anything, and she said quite authoritatively, well, that's right, the First Minister in Scotland is the ultimate parent legally, isn't that right, in front of her children? And I was like, oh, no, that's not correct. But I wondered whether there's this kind of strange perception that there is almost a hierarchy of, you know, you would leap to, like, for example, you know, the corporate parent within the local authority, feeling which it then becomes, you know, whoever the First Minister is at any particular point, which feels a bit ridiculous, but actually is a kind of natural extension of the corporate parent idea. And I would like to see that, a move away from that concept as well.
Any fans of corporate parenting want to come back on that point? Or there's a question right at the back. Ian? Oh, sorry, I think you were first, sorry. We'll have the question in front.
Professor Norrie, you've travelled the world. We've mentioned Africa and other continents. I'm a child of Africa. I'm not a social worker. I'm not a lawyer. We sit here in a church. You've met people of faith and no faith. You've consulted with parliaments, advised people from other religions. One of your slides mentioned Mother Superior. So there are other faiths around the world which also believe in immaculate conceptions. What's your view of cases coming to Supreme Courts on this matter?
The question of who a parent is very seldom gets to the Supreme Court. And when it does, it's not really about who the parent is. This is the point I was trying to emphasise. It's adult interest. One of the other things I didn't cover here was all the European Convention cases on paternity disputes, which have gone to Strasbourg. And I find them artificial in the extreme, because they're all argued, oh, this child has a right under Article 8 to a family life, which means recognising this man as the father, and the fact that many countries in Europe don't let the non-husband challenge is always challenged. Usually, the child who is making the claim is aged 4. It's not the child who's making the claim at all. It's the parent. And this takes me back to the UN Convention. One of my abiding worries about the UN Convention is that it will be used by parents to further parent interests rather than actually children's interests and children's rights. And I think we will have to be very careful. I'm really only speaking in British and European terms, but I suspect that phenomenon is similar in other jurisdictions too.
I'll try and keep it brief, Neil, because it was really in response to your thing. Did anyone want to at all attempt to defend the corporate parent having been thoroughly trashed from the stage from a legal point of view? So I won't do that at length, but I think many people are uncomfortable about the phrase corporate parent, but I think I just wanted to kind of raise the possibility that it had led to some good outcomes, we might say, or good actions by local authorities and other bodies who have been, through this mechanism, invited to consider the needs of children separated from their parents and as to what they, whether it be health boards or local authority departments, could do on behalf of children. So I think it has been a device which in Scotland has had some good outcomes, but I do fully accept, of course, that it doesn't have any or much clear legal standing at all or legal definition. So I entirely accept the solicitors, the legal views on this. But I think it is, again, picking up Professor Norrie's view about the social reality that in trying to increase the effectiveness of local authorities in particular who take over the parenting of children to do it more thoroughly and with more care. So I just want to offer that defence of recent years of the corporate parenting actions. That's all.
I think that's a really important contribution. I did not mean to trash the idea. I'm not that keen on the terminology, and going through all out of what I was saying earlier, the words we use matter. So I'm not keen on the idea, on the words, but there is good in the intent behind the notion and good outcomes as well. Strathclyde University is a corporate parent, and it has quite a good corporate parenting plan, a corporate parenting strategy. And what it involves is identifying any of our students who have spent time in care, who used to be looked after children, and additional support and help is provided for them. And this was shown very, very clearly at the start of the pandemic, when everything went online. And we kind of assumed that all our students had laptops and could go on to Zoom and do their classes that way. But of course it wasn't true. And the major justification for the idea behind corporate parenting is that the long-term life outcomes of children who have gone through the system are disastrous, are absolutely disastrous. And if institutions like this university, and every other university, it's not just Strathclyde, institutions like universities, local authorities, all bodies that have a requirement to be corporate parents, if they can actually provide some help and support to these children, who are now adults, of course, to make some difference, to make up for the losses that they suffered, then that has to be a good thing. So it was just the terminology rather than the idea.
I'd just like to add that's exactly what I was going to say. It's the terminology that I have an issue with, not the ethos and the amazing work that whether you're in a local authority or corporate parenting within another institution, it's the terminology. It's the word corporate attached to parenting, which makes it sound clinical in some way and detracts from the concept that a parent is a person, that parenthood is somebody who parents. But absolutely in terms of providing a structure within which an institution can oversee the care, particularly of care experienced young people and so on, it's absolutely vital. Maybe we can have a challenge to try and think of a better name for it.
I always liked aftercare, which we've used for decades.
Did you want anybody else who wants to find
There's a question over there.
Nicky Campbell here. Sorry if my voice is a bit hoarse.
That's all right.
It's a seasonal flu. The term corporate parent, I've worked in health and social care for more than 35 years in various organisations. We've had an independent care review. We've got the promise we're trying to fulfil by 2030. And part of that is about communication and language. The term corporate parent, young people don't recognise it. Professionals who hear it don't understand the duties, the responsibilities of any of that. We're trying to be more trauma informed. We can't be saying to young people, I'm your corporate parent. It's just not on. Second to that, a good example in local authority that I've witnessed and was really pleased to be part of was a chief executive getting all the senior leaders from all the departments in the council together and using that opportunity to embed the actual sense that you are a corporate parent for the children who are looked after by the local authority if they seek an experience in computing and motor mechanics, whatever it might be. The chief executive described it, we are their biggest family. They should not be not wanting to do something when we have the resources and people here to give them that chance. And that's what it really means once it's boiled down, taking away the corporate parenting label. We don't want labels. The Care Inspectorate, everyone is trying very hard in the language and communication to boil it down to what does it actually mean. So that's my comments on it.
Words are always important, but words have to be context specific and understandable to the people that the words are directed to. One of the good things, one of the many good things about the current consultation on the children's hearing reform is that they're trying very hard. How can we simplify the language here? What do we need? What bits of language do we need to change so that it's more understandable and more accessible by young people? I think that there is a lot of work that we need to do there. Relevant person. I mean, if anybody, there'll be a few panel members here trying to explain to a grandmother she's not a relevant person, you know, and then you get lawyers like, well, it's just a legal construct.
We're out of time, but Ruth, do you want to make a quick point?
Yes, I really didn't want us to get hung up on this corporate parent business because actually to a child, their parent is still their parent. And actually, we have introduced, and I want to just say that it's our fault that we have introduced this kind of irrelevant language like corporate parent, like relevant person. Because it's how the young person sees the people around them, and how, and I think it does relate back, Professor Norrie, to your your initial points about what's a parent's function, and part of a parent's function is that emotional development, that psychological development, and it's quite difficult to do through the mechanism, through this artificial mechanism of a local authority becoming being titled with this parent role. It doesn't happen. It isn't reality for the child. And maybe we need to conceptually start thinking about a different way of doing it, and perhaps learning from other places around the world about what does a family actually mean? Because if you go to New Zealand and to Maori concepts, a family is a friend, a neighbour. It's more than the genetic relationship. And I think there's something that we really have lost a bit of in the last 50 years of since Kilbrandon actually envisaged that we would have much more community resources and community involvement in helping children develop. So I think this is going back to some of the first principles in section 12.
Thanks, Ruth. Andy, you've got a quick point to make. You want to the mic's on its way, and then we should finish because we're...
Andy Kendrick, retired Professor of Social Work at Strathclyde University. It's just a very quick point because I did some work on, it was an article about the family metaphor, and it's the way that children, young people in residential and foster care would talk about. He's like a dad, she's like a sister, and they're very aware that they're not the dad, they're not the sister. And it clicked with, my dad had two uncles, my Uncle Ernie and my Uncle Tom. I called them uncles, they were my dad's drinking buddies, you know. and it's that idea about, it's going back, and to link it to what you were saying, it's about the centrality of the child. It's about the way in which children, young people express and become involved in those relationships, and that's where I see, okay, I go about corporate parenting, but it's those relationships between individuals, foster carers, residential workers, teachers, and children, young people, that I think is at the core of what people around here are trying to do, and I think that you strongly sort of were leading towards in terms of putting the child at the centre. Sorry, quick point. Fantastic talk, Kenneth.
Great, we've now strayed into the time for the drinks reception, so I think it's probably the time to bring things to a close. And this lecture is a partnership between the Department of Social Work and Social Policy at the University of Strathclyde and Scottish Government, and I'm delighted to introduce Brian Taylor, who's Deputy Director of Children's Rights, Protection and Justice with the Scottish Government, to conclude the lecture tonight. Thank you.
Good evening. It's an honour for me to be here tonight to extend my thanks and speak briefly on behalf of Scottish Ministers to Professor Norrie for his exceptional lecture. I also want to thank Professor Ian Rivers for his introduction and Professor Neil Quinn for chairing tonight's lecture. And my thank also to Jane Kirkhope for her response. I want to thank the organisers of this event, Raymond Taylor, Dr. Graham Connolly and Nadia Mitchell, and I'd also like to thank all of you for coming this evening, and I hope you will be able to take the opportunity to stay for refreshments and share some reflections on tonight's fascinating lecture with each other. This lecture series is not only a fitting way to honour the legacy of Lord Kilbrandon, but it's also a valuable learning opportunity for those of us working in and around the children's hearing system. I'm pleased to let you know that tonight's lecture will be available on the University's Kilbrandon website, and it will also be published on the University's Journal of Residential Childcare. It is, of course, a time of reform and evolution for the children's hearing system. The Children Care and Justice Act is already making a difference to children, ensuring that no one under the age of 18 is placed in a young offenders institution. Crucially, the Act will make the children's hearing system accessible to all Scotland's children. In conjunction with the Promise Scotland, the Scottish Government is committed to redesigning the hearing system, and that work is gathering pace. Sheriff David Mackey's Hearings for Children report was detailed and ambitious, and our response reflected and accepted the challenge which was laid down for a redesign of the system. Our recent public consultation, which has been referenced with its many questions, on the legislative foundations for redesign garnered a lot of interest across the sector, and we've received a lot of diverse views, as I'm sure that will surprise no one, regarding the best ways to improve the experiences of children and families. But across all the responses, it is clear the extent to which Kilbrandon's vision endures to this day. As we continue our work, the principles of Kilbrandon, in whose name we are here tonight, will remain central to our thinking, as will the voices of children and young people, particularly when it comes to the key relationships in their lives. It's fantastic to see the expertise and commitment on display, and all the work that goes into improving the lives of Scotland's children, and how it's been demonstrated tonight. Those lives are often complex and chaotic. Our laws need to be able to account for that complexity. The relationships that matter most to children must be protected, especially when a child is in need. In conclusion, I want to return to Professor Norrie's lecture and to give some additional thanks, I think, for helping me, for inspiring me to question the legal and natural order of things. I'm also giving some terrible foreshadowing of some discussions I will have with my children, who are currently 5 and 7, as to the artificiality of age restrictions and what they're actually able to do. There's also been some arresting imagery. But what's really clear is your deep knowledge and how it's matched by the passion for your work. The words really have been fascinating, and there's also been some discussion which I'm sure will continue later on this evening and beyond. It's heartening to know that your passion and commitment has been passed on to the generations of legal graduates, children's panel members and social workers that you've taught. Thank you again.